All right, let's continue with our week 2 lecture and talking about mootness. And again, we're looking at reasons why someone would not be able to successfully sue, where areas where the court restricts its ability to make a decision because, in these cases, no decision should be made. Now, you see the image I have here is a man sort of shrugging his shoulders. Why? Is what this image is saying. And when you think about mootness, the question should come to mind is why bother suing? Because that's really what it gets down to. In a case that is moot, relief can no longer be granted because either the problem no longer exists or the relief that was requested has already been granted. For example, let's say I wanted to buy a car, and no, that's a bad example. Let's say I owned some property and my neighbor had a tree that was dropping all sorts of yucky stuff on my land, and I wanted my neighbor to trim the tree or cut the tree down, and he refused, and I sued him. And in the process of us going through the legal action, there was a big ol' huge storm that knocked the tree down. So the tree is no longer there. So when we get to court, the attorney for my neighbor would say, this case is moot. She wanted the tree to be removed. The tree has been removed. There's no point in going forward with a lawsuit. And so that's the idea of mootness. What is the point of suing at this time? It doesn't make any sense anymore. This idea of mootness comes up a lot in abortion cases, and I think they mention that in the text. Or anything having to do with pregnancy, really, or other things that are very time sensitive, because you've probably gathered that the process of suing takes a long time. And if I, discovered I was pregnant and wanted to have an abortion at week 33 and I was denied, really, before I'd even have a chance to get to trial court, I would have either had the kid or, the issue wouldn't be around anymore. I would have either had it or had abortion by that point. And so, no case ever really makes it during a 9-month period. And so, if mootness was always allowed to prevail, cases like that would never be heard, which I know would make a lot of people happy. But I think the court needs to make, decisions on these matters. And so that's why sometimes they overcome the mootness argument, because in some cases, as the text mentions, if the mootness argument were allowed to always win, then there's some cases that would just never get to court. So keep in mind, you can really describe mootness as there's no point in suing at this time, and that really gets to the essence of it. The next area is a specific plea. And a story popped into my head when I was reading this in the text. When they talked about offending the values of the founders or offending the Constitution, that sort of vague, there's all sorts of things that could offend the Constitution or the values of the founders, and it's just too vague a reason to sue. There needs to be something really specific. And I had a case that I was representing a couple of gentlemen who were renting a house, and their landlord had just treated them badly. And after a while, the landlord tried to kick them out because they stopped paying their rent. And they stopped paying their rent because they felt like the landlord was treating them badly, which is generally not recognized in the law, in Seattle at least, as a reason to not pay your rent. So they came to me looking for me as a volunteer with the King County Housing Justice Project, and they wanted us to represent them. And what they wanted was they were planning to move. They didn't want to stay. They didn't like their landlord. They wanted to get into a better situation. But what they really wanted was for the court to order their landlord to apologize for treating them so badly. And really, that's not a relief that the court can grant. That is not a specific plea. The landlord had a specific plea, pay me my rent, but they wanted to countersue for an apology, and really the court can't do that. There needs to be some monetary remedy or some action, but saying I'm sorry, not something that the court can grant. We'll come back for the last part of this lecture talking about precedent.